The English poet Robert Burns famously wrote, "The best laid plans of mice and men often go astray, and leave us naught but pain and sorrow for promised joy." If you're an employer who feels mugged by the workers' comp system, you know all about how your plans and efforts seem to go not only unrewarded, but sometimes resented by the injured worker. As an employer, if you felt betrayed when your employee retains counsel, your first question was likely, why? It's a natural reaction for an employer who sees his employee girding for a battle that did not need to happen, and which the employer feels that he earnestly tried to avoid. Perhaps the correct reaction to the question, "Why did you get an attorney?" should be an effort to understand the perspectives of the parties involved. So what are those perspectives? Each side considers itself the victim, and the other side the offending party. For the injured worker dealing with pain and with concern over what will happen with his body, his job, or how to pay the bills, he feels entitled to his victim status. Many of his concerns are legitimate and completely outside of the experience of his employer. For example, workers' comp benefits do not immediately cover the first week of disability. For the employee living paycheck to paycheck, missing that income is a problem. The employer, who is not aware of the financial strain which the disability has caused, has missed an opportunity to disclose to the employee how the comp system works, so that the employee could adequately consider whether a modified duty position is possible so that lost income is not a problem. So when the employee does not know his rights, he will seek those answers where he can find them, be it a TV advertisement or a simple Google search. The employer is meanwhile nursing his own grudges. No matter what, the employer feels the victim, as the system seems stacked against him and in favor of the poor injured worker. Pay for medical treatment and lost time, your reward is a higher premium. Ignore the claim, your reward is a claim out of control and an even worse experience rating next year. Pay attention to the needs of production by not returning the injured worker to accommodated duty. The claim gets more expensive. Accommodate the restrictions and bring the employee back to work, production goes down, employee morale suffers, and your HR department is transformed into a glorified babysitter. Either way, from the employer's perspective, the employee and the state board seem to resent and second-guess everything that he's done. If experience is what you get when you don't get what you want, then it seems that the comp system is designed to produce experience. It would be hard not to come out of a claim a little more cynical than when you began. Any employee who's laid out of work for an injury, for the flu, or just a day off has been deluged with ads telling him that the insurance company has hundreds of lawyers looking out for the insurance company, but that the injured worker is on his own, unless they call that easy-to-remember 1-800 number. During sweeps week on the local news, employers are treated with exposés of supposedly injured workers playing basketball, lifting weights, or working elsewhere while drawing disability payments. With these images never far from the front of our minds, perhaps our cynicism is understandable. As unfair as it seems, the employer has the first opportunity to set the tone for the claim. Instead of asking, "Who is at fault?" we would suggest first that appropriate medical assistance be given. Stop the bleeding before looking for the root cause. Rather than complaining about who the employee has chosen for treatment, comply with the statute. Post a panel and control the medical. Don't complain about the employee's requests or demands. Figure out what he needs and know whether that need is something that you should or could help to cover. If the employer doubts the employee is injured, prove it. Get the right medical care and document the lack of objective findings. If you doubt that the problem relates to your workplace, can you prove that? Does your personnel file support the fact of pre-existing conditions? If you convince the employee that you don't have time for his claim and that you don't have time to get him through the comp system, he will seek his answers elsewhere, most likely from someone who gets paid to make your life more difficult. In short, keep the employee active, keep him at work, and convince him that ongoing employment is a better investment of his time than as a workers' comp claim. A common theme for the complaints of the injured worker is the impenetrable nature of the system. Face it, for most injured workers, they're not frequent filers, but will instead have one comp claim in the course of their careers. If you think the system is difficult for the employer to navigate, try looking at it from the perspective of the person who has no clue what an experience modification rating is, how much work comp premiums cost, or what the heck a nurse case manager does. Consider the case of the injured worker who really wants to get back to work, and then think of the number of people with whom he has to deal just so that he can get back to work. The employer who has not explained to the employer the complex nature of the system has again missed the opportunity to lend a little transparency and predictability to the system before the concern arises. Some workers sense the adversarial nature of the system and respond accordingly. For example, as part of the investigation, drug tests are sometimes obtained. Even the employee who is confident of donating a clean sample might bristle at the drug test unless he understands that the employer, as part of a drug-free workplace, obtains such tests as part of every claim. Or an employer might obtain recorded statements. An employee might object to those recorded statements given to a carrier unless he understands that the statement also protects him from being misunderstood and from having to repeat himself. The solution to the perception problem is advanced preparation. The employer needs to know what he can say and do. The employer should understand that simple human compassion is neither an admission of guilt nor a sign of weakness. If you can help the injured worker, you probably should. The employer should also know about his employees. He should know, for example, whether they have pre-existing conditions that need accommodation. If the employee is a problem employee, you should know about that long before an injury happens and make sure that the personnel file reflects it. In the end, whether your injured worker has an attorney or not, your obligations as an employer are the same. Your employee will mirror your views of the system. Treat him as an adversary, you can bet he'll respond. Convince him that he needs an attorney to watch his back. Soon enough, you'll need the same. Most often, the process is about managing expectations, yours and the employee's. Thanks for joining us. If you want to stay informed about other workers' compensation topics, check out our library, our Twitter feed, and our Workers' Compensation Answers blog at skedsvoldandwhite.com.